Hello, everyone. If we could go ahead and get started. And for those of you in the back, just fill out the CLE forms should be available for you. Just go ahead and grab them. Welcome, everyone, to the University of Houston Law Center for our very special event. We're very excited about it, for a mock U.S. Supreme Court oral argument on the issue of climate liability in tort. I'm Professor Tracy Hester. I'm the director of the Environment, Energy, and Natural Resource Center here at the Law Center. I want to take a few brief moments to tell you about the EENR Center, then tell you a little bit about the case that will be the subject of the oral argument today, and then step aside and let the arguments begin, introducing our speakers. First of all, a few logistics questions. For those of you who are here who would like to get CLE credit, I wanted to remind you that we do have CLE forms in the back. Please sign and leave your forms there. We'll take care of it from that point onward. Second, I want to alert everyone that this is being streamed live on the internet. So if you have an urge to ask something particularly outrageous, just remember you may be heard anywhere in the world by the time you ask it. Let me begin by saying a few things about the EENR Center. It is a center established specifically for an issue that is of predominant importance in Houston. Namely, it studies the intersection of legal issues between environment and energy. As you might expect, given controversies currently in the energy world over environmental questions on fracking, questions about greenhouse gas emissions and global warming, questions about the overall impact of fossil fuel energy production on the environment, as well as its use on its impact on the environment. There's a host of things that the center can focus on, and we have a great opportunity to take advantage of the deep well of experience and resources in Houston to do so. We are very privileged to bring excellent speakers to address those issues here in Houston. We also strive to provide opportunities for students to meet leading thinkers in this area and provide reports and research to help guide some thinking in that area as well. If you're interested in the EENR Center, there's a website page on the University of Houston Law Center page that provides information about the center. It also provides an update on environmental legal events taking place in the city of Houston. So if you would like to find out what's going on, we try and maintain a calendar there, and we look forward to meeting you there. Also, that web page has the link to the web streaming that's taking place today. So if you'd like to come back and revisit the arguments today or have questions about it, it will be posted there for future use. With that in mind, let me now provide a little bit of background on our topic for today. We are going to be hearing a mock Supreme Court argument on the question of climate change liability sounded in tort, particularly in public nuisance. This is an issue that is currently receiving a great deal of attention in the federal court system. As you may know, and I should say as a preface here, there is a brief description of the scenario that we're going to be discussing today at the back of the room. If you haven't gotten one, please grab it. One other minor logistic point I forgot to mention as well. I know several of you are students who have classes at 1 o'clock. We understand. We only ask that if you could leave quietly towards the back, because we will still be having oral arguments and question and answer sessions afterwards. As I was saying, the federal courts are addressing the question of climate change liability. There are actually 3 cases that have focused a great deal of public scrutiny and media attention, one in the Second Circuit, one in the Fifth Circuit, and one in the Ninth Circuit. The Second Circuit court case is actually described in the handout that most of you have here today. It's the Connecticut versus American Electric Power decision. In that decision, the U.S. Supreme Court ruled that federal common law that would have provided a public nuisance claim for emissions of greenhouse gas emissions was displaced by the passage of the Federal Clean Air Act. However, interestingly, while that decision was unanimous, 8-0, Justice Sotomayor had recused herself because she participated in the Second Circuit decision below, that decision split 4-4 on whether or not there were questions of political question of justiciability and standing, which the court did not rule on. Therefore, those issues have not been conclusively resolved in a way that might affect the other case that we're focused on today, which is the Village of Kivalina versus ExxonMobil. This decision is currently before the Ninth Circuit. They had oral argument on it about 5 weeks ago. This decision deals with a village of Native Alaskan Inuits who live in a small village on the western coast of Alaska. This village, if you can imagine, is on a narrow spit of land that has water on both sides. It is so small that you can actually picture the village being built in a line where the housing is in one part and then the airport and the dump. The issue is that the village has been in the past protected by sea ice during the winter that kept storms from eroding away the coastline. Well, as temperatures have risen, the pack ice has become less and less permanent, and they've seen increasing erosion of the village to the point where parts of it are literally falling into the ocean. They have brought a lawsuit claiming that that the erosion is the result of greenhouse gas emissions from a collection of oil, energy companies, chemical companies, other emitters of greenhouse gases. And they are seeking specifically not an injunction to halt or modify the greenhouse gas emissions, but only damages for the relocation of the village, which the Army Corps of Engineers is estimated to range up to $400 million. That lawsuit was brought in the district court in California and was dismissed on grounds of political question, as well as on grounds of standing. It has now been appealed to the Ninth Circuit. Oral arguments have been had, but we have not yet had an opinion. The oral argument we're going to present to you today is going to assume that the Ninth Circuit has upheld the district court, and that therefore this is an appeal to try and revive those claims. We have an extraordinarily distinguished bench to rule for us today. We have Justice Tom Phillips, former Texas Supreme Court Justice, a very well-known figure in the legal community here in Texas, and is currently a partner at Baker Botts. We also have the Honorable Ken Starr, who has an illustrious resume. Hopefully he's sitting behind me and not being embarrassed. I will say that he is one of the rare people who have also been in a Solicitor General, as well as a federal appellate judge in the DC Circuit, as well as currently the president of Baylor University, as well as a former special prosecutor. So he brings a wealth of experience and different perspectives in one person to this issue. Our third panelist, judge, is also very experienced. He is John Cruden. John Cruden is currently the president of the Environmental Law Institute. He has been in that position for about the past half year, but most interestingly, before that as well, he was the senior career attorney in the Department of Justice's Environment and Natural Resources Division, rising to the point, I believe, of acting Deputy Assistant Attorney General. John's position there meant that he was actually involved in some of the briefing and argument on the Connecticut versus AEP decision that the Supreme Court decided. He will bring the environmental as well as some of the other direct experience in this case to the oral arguments today. With that in mind, I will step aside and turn the podium to our justices. Our hope is that while you're hearing the argument, we will have an opportunity for them to provide comments on the argument afterwards, but then we intend to turn the mic to the floor. So be thinking about questions you would like to ask these justices after you hear the argument today. Thank you for coming. I look forward to the presentations coming up.
Court calls for argument in the case of Native Village of Kivalina and City of Kivalina versus ExxonMobil Corporation and others.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are invited to draw near and give their attention, for this court is now sitting. God save this court and the United States of America.
Thank you. Be seated. Court is ready to hear argument from petitioners.
Chief Justice, and may it please the court. The village of Kivalina alleges that the defendant's emissions of greenhouse gases have substantially contributed to the injurious phenomenon of global warming that has damaged the village of Kivalina to the point of imminent destruction by melting the sea ice that has formed a barrier, a protective barrier that has prevented the erosion of the island from the ravages of winter storms. Both the Army Corps of Engineers and the General Accounting Office have concluded that unless the village is completely relocated at a cost of millions of dollars, the village will be completely destroyed. Under these circumstances, the village of Kivalina has Article 3 standing to pursue a common law public nuisance claim for damages, a claim that is well within the competence of the federal courts and does not offend the political question doctrine. As to the issue of standing, the village of Kivalina's allegations at this pleading stage of the case more than satisfy the requirements for Article 3 standing. First, the village has alleged an actual concrete, particularized injury, an injury different in kind from any that the general public might suffer as a result of global warming. That is the imminent destruction of the village. The village does not seek prospective or injunctive relief for this injury, but rather only an award of damages which will redress that injury. And the allegations of the complaint demonstrate that the injury suffered by the village of Kivalina is fairly traceable to the defendant's conduct. There is no requirement under the law that the village trace its injury molecule by molecule to the specific conduct or a specific product of a specific defendant. All that is required to satisfy both the requirements of Article 3 standing and the requirements for proof of a public nuisance claim for damages is that the plaintiffs demonstrate that the defendant's conduct was a substantial contribution to the indivisible, injurious phenomenon of global warming.
In this context, which is unprecedented, the courts are being invited by you and your clients to address an issue in a very traditional legal forum, and indeed you're seeking the quintessential legal remedy of damages. And that separates this out from trying to run the country, so to speak, or run private industry. And yet I will say frankly that I'm troubled, because it seems to me that in light of the, and I think you don't contest this, the myriad contributors to global warming, you have selected certain sort of unlucky characters who are contributors to greenhouse gases, and therefore to, assuming that this does cause, as I'm prepared to concede, global warming. But it's the very fact that you have chosen just a certain number and to bring the forces of law to bear on this certain select group, the unlucky 10%, shall I say, contributors, that seems to me to kind of tug at separation of powers values. And I know we're going to come to that in the political question, Doctor, but I think standing in this context is kind of a proxy for should the courts really be involved? Is this the kind of lawsuit that would have been resolved by the courts of Westminster?
I appreciate your concern, Your Honor, but it is commonplace for plaintiffs to sue what turns out to be a subset of those defendants that might ultimately be liable. But that does not preclude the plaintiffs from seeking redress for their injuries, particularly at the pleading stage. The law has a self-regulating mechanism to resolve problems of that sort, and that is the defendant's freedom to bring actions for indemnity or contribution to bring in other actors who may need to be brought into the mix.
And so help me think that through. Should they bring in Greyhound and Trailway bus lines? Should they bring in municipal systems that have not shifted to cleaner forms of energy, be it electricity or natural gas?
Well, here again, the law has a self-regulating mechanism to avoid the problem of the de minimis contributor. The plaintiff, and presumably a defendant who brings in another party by contribution or indemnity, will have to prove that the defendant or the additional party's conduct was a substantial contribution to the phenomenon of global warming. Only by proof of that substantial contribution will there be a liability, and that mechanism will weed out the de minimis contributor.
And given the global nature of global warming, how would you prove substantial versus insubstantial?
That is a matter for proof at trial. There may be...
So this will have to be tried, and you will bring in, Peabody Coal will say, well, you didn't bring in Acme Coal. So that's the way this will likely unfold. And this really does bring us back. I'm really not in the political question, Doctor. I'm still really trying to focus on, is this the kind of injury that the courts are equipped to handle, to resolve?
The specific science, the specific proof that may be required of the plaintiff is a matter for the trial of the case. There may be skepticism as to whether or not the plaintiff will be able to prove its case at trial, but skepticism does not permit dismissal. And as far as the complexity of the matter, our courts handle cases that are equally, if not more complex than this case in the host of environmental and toxic tort cases that populate our courts on a daily basis. So
really? As complex as greenhouse gases and global warming?
Well,
now I find that assuring if you could provide
as a matter of
examples.
fact, the theory underlying the plaintiff's allegations, the causal chain alleged in the plaintiff's complaint, is rather simple by comparison to the chain of causation that is often alleged in environmental cases.
But Counselor, on that very point, why isn't standing here extraordinarily straightforward? Why is this complete question not already controlled by ground that this court has already plowed? We said in Massachusetts versus EPA that governments were entitled to special solicitude. I take it your position is that the tribe is a government that's being harmed. Why isn't that absolutely controlling now in this discussion?
Well, we would agree that the parens patriae status of the tribe should entitle the tribe to that special solicitude that this court recognized in Massachusetts versus EPA. But even if that were not the case, this claim can go forward in part because of this court's holding in Massachusetts versus EPA, which acknowledged and independent of its parens patriae analysis, acknowledged the substantial contribution theory which is at the core of the plaintiff's allegation.
All right, now explain for me, if you would, this court also considered standing issues in the decision that we had of last term in AEP. What happened in standing there, and is that relevant?
Well, I believe this court divided equally, 4-4, leaving intact the Second Circuit's decision that there was standing and that there was no political question involved. And we would agree with the Second Circuit's analysis that as far as both standing and political question, the plaintiff's allegations more than satisfy the requirements of the law.
So in the big, huge greenhouse gas cases, Massachusetts versus EPA, this court found standing, and the second big one that existed, AEP, we accepted the decision by the Second Circuit that there was standing. Why isn't that the end of the discussion?
Well, we would agree that to the extent that the tribe is entitled to the parens patriae status and the special solicitude that goes with it, that Massachusetts versus EPA should govern to acknowledge standing.
Let me quarrel with that just for purposes of the argument. After all, Massachusetts, the Commonwealth, the sovereign state, was simply seeking to have a federal agency with authority granted by Congress to regulate. The EPA had declined, and a sovereign state believed, given its interpretation of the Clean Air Act, that it was derelict. And it was simply saying, courts, we need the agency to do its job. You're doing something quite different. You're asking a select group of people who have not been commanded by EPA not to carry on their work to start writing very large checks, and therefore we know from many cases you're seeking to essentially, through the device of damages, to regulate an industry that is thus far not regulated in this particular by the federal government.
I would disagree with your characterization of what the plaintiffs are seeking to do in this case. All that the plaintiffs are seeking to do here is to apply well-accepted common law principles of public nuisance to a specific case and to adjudicate the damages claim in that specific case. Our case does not seek to set national policy. It does not require the setting of national policy.
But it does. And surely, if you're asked to write a check for $100 million, then you must take action as someone who wrote the check to stop doing what you have been doing. That's just a form of regulation, and we've held in any number of cases that a damages action under tort law is in fact a form of regulation. You're trying to regulate the industry, but not in the sense of shutting down the industry, but you're asking the industry in effect to self-regulate while EPA is studying this. And I realize it's sort of bleeding over into the political question doctrine, but just on purpose, in terms of this fundamental difference between Massachusetts and EPA.
The adjudication of the common law claim for damages in this case will no more set policy than the host of environmental and toxic tort cases that are adjudicated on a daily basis in our federal courts without ever offending the political question doctrine.
I think we bled over into political questions, so you can handle more standing if you get more time or when you come back on rebuttal. But on the political question case, in most pollution cases, or what we ordinarily think of as a nuisance tort, there's only losers. But as George Will tells us and the scientists explain, there's going to be winners and losers. And even within Alaska, perhaps very near to this village, there will be winners. There'll be people who will be growing bumper wheat crops instead of just cutting holes to fish for ice. Doesn't that make this more of a political question than the ordinary case of a bunch of soot drops down on your land and you need to clean it up?
No, Your Honor. The political question doctrine does not provide that the courts can avoid exercising their jurisdiction simply because a case is politically charged. The political question doctrine is designed to preserve the separation of powers. In the first instance, adjudication of common law tort claims, such as the claim alleged here, has not been textually committed by the Constitution to either the executive or the legislative branch. If anything, the adjudication of common law tort claims is textually committed to the judiciary. Nor are there any prudential factors that argue in favor of applying the political question doctrine.
What about the ongoing, I'm just struggling with this. EPA was resistant to even trying to regulate, and then the Supreme Court, this court, by narrowly, I hasten to note, 5-4 margin, said, no, EPA, go do your job. But isn't it still in the process, it being the EPA, of trying to wrestle with this extraordinary issue, and the Kyoto Protocol, which the United States refused to ratify because of the global nature of this? It's almost over our heads, as we're sort of beyond our compass. How do we get our arms around it?
Your Honor, it is precisely because the federal government has not set a comprehensive policy with respect to greenhouse gas emissions that it is entirely appropriate for the federal common law to be applied to fill those interstitial gaps, and especially with regard to a phenomenon of nationwide scope and importance. And that is all that is being done here.
And Counselor, I want to take you there because I think this is the heart of the discussion and what this court must ultimately decide. Obviously, in AEP, this court very clearly stated that there is a federal common law, and we made it very clear that pollution issues can and be a part of that. But we also said that in the case of carbon issues, there was displacement by what EPA had done. So I ask you two things. What is your position on displacement? And then second, what difference does it make that the Congress of the United States, at least the House of Representatives, has been busy working to undo many of those Clean Air Act laws that we relied on when we decided AEP?
As to the first question, there may be displacement as to those actions which seek injunctive or prospective relief, which could impose a parallel regulatory regime that would offend the political question doctrine. But this court's decision does not displace the common law action for damages, which is limited to an adjudication of this one particular case. And as far as actions that may be ongoing in Congress, let us not forget that the Congress has articulated a policy in favor of the regulation of greenhouse gases, in favor of curbing those greenhouse gases. So although there is no, we would say there is no need for a policy to be articulated in order for the courts to proceed, if there were a need for a policy to serve as a check on the courts going forward. That policy has been articulated by our federal government.
If and when the EPA does promulgate these regulations, does our compass of what standards we can set under the common law narrow or change?
That remains to be seen. If the Congress were to decide that the ongoing adjudication of claims, such as the claim brought by the village of Kivalina, did encroach upon the prerogative of either the executive or the legislative branch, the Congress would be free to either preempt or displace those types of actions. But it has not done so, and until that happens, the courts may not shirk from exercising their jurisdiction to adjudicate these common law claims.
Imagine, if you would, a hypothetical expert witness who had served at a senior capacity in the State Department who would be testifying at the trial that you're anticipating, since you're emphasizing the fact this is now in the pleading stage. Dismissals at the pleading stage are not likely to be undertaken, and I very much appreciate that point. I think it's a foundational and important point. But let's imagine that this State Department official testifies before a United States district judge. If this court gets involved in this, this is going to interfere with negotiations with China, all the BRIC countries, because frankly the United States is a leader in this area and China is a scofflaw. And so, by the way, is India, and so, by the way, is Brazil, and so, by the way, and then we have the list of countries that have not been, even if they're signatories to the Kyoto Protocol, as sensitive as the United States has been to the overall issue. And Peabody Coal says to you, or Exxon, you know, Judge, it's just something fundamentally unfair with our having been chosen. They're playing Russian roulette with us because they know we are able to pay the judgment. But there's something fundamentally unfair about this. And the reason that it's fundamentally unfair is it is ultimately a political question to be resolved by EPA, which can be reviewed by the Congress. You can't be reviewed by anyone other than a court of appeals, and then ultimately by this court. And also, the final thing I would say in this respect is just the institutional capacity. How do we just wrestle with these issues of what our role is versus what the EPA's role is, what Congress's role is, and what the State Department's role is?
I would respond in two ways. First, the fact that a case may have political or foreign policy overtones does not mean that it presents a political question that offends the political question doctrine. And secondly, the complexity of the case is no basis for dismissal of the plaintiff's claim. The federal courts are more than capable of handling complex issues of this sort.
Well, we're not writing here just on a blank slate or even doing what we prefer to in an ideal world. We've got 6 factors from Baker versus Carr on when a case presents a political question. And let me ask you about some of them. Number 3, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. Given back to my winners and losers, the fact that this is such a complex issue, it's so complex about what the citizens of Kivalina might do if they got $400 million. How come this is simply not a judicial determination?
I see that my time has expired.
You can answer that question. And then
but I would simply say that the federal courts do not need an articulation of a federal government policy or the setting of greenhouse gas emission levels in order to adjudicate the specifics of the tort claim at issue here. The standards provided by the common law are more than adequate to guide the courts in adjudicating these types of claims.
Thank you, counsel.
And with that, I'll reserve my time for rebuttal. Thank you.
Court is ready to hear argument from respondents.
Mr. Chief Justice. Mr. Chief Justice, may it please the court. The petitioners in this case, throughout their argument, have emphasized that this is simply an ordinary tort case. It's simply something that courts do every day. They decide the reasonableness of conduct. They decide whether something is a substantial contributing factor, and this case is no different than any of those. I respectfully disagree for several reasons. One of the principal reasons, however, is that this is an Article III standing case. And Article III standing is very different from the issue addressed in Massachusetts versus EPA, because in that case, that wasn't an Article III standing case. That case dealt with a case filed pursuant to a specific statute which allowed that sort of judicial review for Massachusetts to try to force the EPA to regulate carbon dioxide as a particular pollutant. That statute does not apply here. Article III standing applies to tort cases, and Article III
Do you
standing...
agree that we owe the same deference to this native village as we would to a state coming in as a litigant?
The answer is no, Your Honor, it does not. This state does not even have territorial sovereignty over its property. The village of Kivalina is owned by an Alaskan corporation that was created when by the state or by the territory when in fact the territory entered the Union, entered the United States territorial domain. This village of Kivalina does not have parents patriae authority here. As a matter of fact, there has never been in the history of Supreme Court jurisprudence any case involving a federal common law public nuisance which has not been prosecuted by a state. Massachusetts versus EPA, for example, Massachusetts was of course a state. And in Connecticut versus American Electric Power, in that particular case, which this court decided last year, the court remarked when it decided that at least some of the entities in that case had standing. I suggest, although I'm not, of course, trying to read the mind of the court, I believe that comment infers that the state of Connecticut that was involved in that controversy was indeed a party that had the authority to bring that action.
Counselor, I have a question about your standing argument. I'm a little bit confused. You have now, and in your moving papers, and now today before this court, you have argued specifically Article III standing. As you well know, there is non-Article III standing, a prudential standing that this court has used. Are you making that argument, or are you not making the argument that this court, if it wanted to, could decide on a prudential standing basis?
I'm making the argument here, Your Honor, that this is an Article III case because this is a tort case. And prudential standing has traditionally, in my experience, been used as a means to decline jurisdiction, not to accept jurisdiction when Article III standing did not apply. And so here, when we talk about Article III standing, I think we need to understand what Article III standing requires. It requires a causal connection between the actions of the defendant to the injury suffered by the plaintiff.
Well, counsel, let me share with you my concern about your position, as you've taken a very bold litigation position because you have moved to dismiss. So there has not been discovery. The usual tools of litigation have not been employed. And I put in mind of this court's frequent admonition in the constitutional challenge arena, woe unto the party who mounts a facial challenge to a statute. I think there's learning to be drawn from that principle. That is, that you must prove, Salerno, that the statute in question being challenged, I'm talking about a different set of circumstances, is unconstitutional in any and all applications. That's really the analogous burden you've taken on here. You're not even going to give the plaintiffs a chance, preliminary discovery, whereas, standing can be addressed, of course, at any time in the litigation. Why shouldn't we at least have some of these experts come on board and we can find out just how culpable some of these plaintiffs are? In terms of a causation connection, to come to your causation point, that they are, in fact, such polluters that they have substantially caused this, and you admit there's tremendous damage to Kivalina. You don't argue with that, do you?
I'm not in a position to argue that they have alleged that they have suffered
exactly, and the reason that you can't do that is because you're here saying toss them out without the opportunity to be heard in court, and that's a daunting burden, it would seem to me. So help me understand that.
And we accept that burden, and there's a very good reason for that. It's because the plaintiffs themselves, in their own complaint, have pleaded themselves out of court. It's not that they haven't pleaded enough, is that they've pleaded entirely too much. They've been very clear, and this is what they've said specifically. It is not possible to state which emissions, emitted by whom and at what time in the last several centuries and in what place in the world, caused plaintiffs' global warming injuries.
That's basic tort law. Sometimes you don't know who fired the shot. We all studied that in law school. But what you know is somebody really got hurt, and two hunters were out there, but we can't figure out even through ballistics who fired the shot. So they're both on the hook.
I'm sorry, Your Honor.
No,
The issue in Article 3, however, is that there must be a nexus pleaded, specifically linking the action, the emission, for example, from an ExxonMobil refinery or a Peabody coal mine or otherwise, to the specific injuries that this particular village has suffered.
Counselor, I'm not sure that is accurate. Let me give you this hypothetical. There are many rivers in the United States that have naturally occurring arsenic in that river. It's a byproduct of mining sometimes. The sources are multitude. Very often they're not known. Does that mean that if we adopt your theory, that a company could come by and willy-nilly add whatever arsenic it wanted to that river because no one would ever be able to say with specificity that their little bit of additional arsenic caused a downstream problem?
No, it doesn't mean that, Justice Cruden, but what it does mean, and as the Clean Water Act cases have shown, from Friends of the Earth versus Crown Central to Gas and Copper to others, is that there's more than simply saying that water flows downstream. To say that someone adds a pollutant to something 18 miles away from a lake doesn't necessarily mean that that particular pollutant has translated into the lake. As a matter of fact, in the Friends of the Earth case, the exact holding was that 18 miles was too far of a leap because we can't simply presume that water flows to downstream to cause the pollution.
But then it seems to me you're making Justice Starr's point. Why isn't this just a proof problem? We have trials all the time. Why are you so reluctant to go to trial, and we'll have experts and we'll have somebody that will resolve that factual issue?
Because it's critical, I think, that given the Article 3 standing requirements that require specific allegations to be proved, given the requirements of the Twombly and Iqbal cases that require these specific pleadings to be made, that before parties are hailed into court, before parties are brought in to deal with injuries that occur thousands and thousands and thousands of miles away from any source of emissions that they have ever had, that they be required to allege conditions and circumstances that show an actual causal link. As a matter of fact, the test of causation under public nuisance is not substantial contribution. That's a liability finding, but causation is proximate cause in public nuisance. And proximate cause is but for causation. But for the actions of the defendant, the damages would not have occurred.
But don't we have to assume, because again you are taking this bold litigation position, which you're entitled to do, that your clients are indeed emitters of greenhouse gases, and that we have to assume that GHGs do in fact contribute to global warming, and we further have to assume that global warming has directly led to the destruction of the ice protection of this small village. If we take all that together, it sounds as if they get their day in court.
Well, that doesn't...
Understanding. Now, I think, in listening to your argument, I think you're bleeding over into political question doctrine. Maybe you are, but then again, you're making your argument on standing, and I'm struggling with it in light of the nature of the procedural posture of the case.
Well, there is a bleed over, if you like, between these two principles. And I think it's important to understand that the controlling issue, namely whether there is a basis for showing a causal link here and whether that is in fact analyzable from a judicial perspective, is a critical question here under both stands. For example, one of the tests in Baker v. Carr is there must be judicially discoverable and manageable standards by which the trier of fact, namely a jury probably in this case, can make a decision as to whether there has been a substantial contribution, a substantial impact, and whether there is a public nuisance. If you look at it from the practical perspective, which Baker v. Carr admonishes us to do as to how a jury would analyze this, you can step back and say, first of all, in order to determine whether these omissions have been reasonable, which is the test under both damages, under the restatement and injunctive relief, in order to determine whether they've been reasonable, you first have to determine what is the reasonable level of greenhouse gas in the entire planet.
Now, aren't
you
there
have to
a
start
fair number?
there.
Aren't there a
work
fair
back.
number of cases, bolstered by the restatement and the great thinkers, that if your conduct causes undue harm to one isolated individual or group, no matter how socially worthwhile it is, you still may owe them nuisance damages, just as a cost of doing business. And if, a handful of villages suffer total destruction, whereas for the rest of us, we just have to buy another short sleeve shirt, isn't that a judicially cognizable difference?
I would disagree with that, Mr. Chief Justice, for the following reason. The restatement of torts, Section 821, Section B, Comment E, which of course they very hardly rely upon the restatement of torts here, says that the test of reasonableness applies both to injunctive relief and to damages. And under those circumstances, a jury is going to have to determine whether or not the damages to the plaintiff are such that the defendant should have to pay for those damages. The factors that go into that is a test of reason.
If they're hurt bad enough, it can be per se unreasonable in some cases. Isn't that true?
I would disagree that there is no such thing as unreasonable as a matter of law. That's a test under the restatement. I would say that Section 821 says exactly the opposite.
And in analyzing reasonableness, which is obviously a balancing test and considering all the circumstances, to what extent does your argument rely upon the fact that the EPA, as interpreted by this court, is now determining whether GHGs can be regulated in a particular way? Is there relevance to that? And if so, what relevance does it have? And how does it weigh in the balance?
With respect to the political question, I think it is a critical point that the management of those standards, the determination of those standards, has already been committed to the EPA, and that the EPA is in the process of doing that.
So why shouldn't we proceed until EPA issues essentially an administrative order that, in effect, interpreting the Clean Air Act preempts state tort actions? I don't think the EPA has taken that action. So you could almost argue it, could you not, from the other end, that the EPA could, aware of these litigations, say, well, we think that's unwise, we're going to issue an administrative preemption order, which Congress can obviously overturn if it wants these actions to go forward.
I'm not here to tell the court what it can or cannot do, but I will say that, of course, in a court
counsel does it all the time.
The court can say, the court will recall in Connecticut versus American Electric Power, the case was in fact remanded to the Second Circuit to make that precise determination as to whether the EPA had in fact preempted the state tort claim actions. And that decision, which is of course going to be made by the Second Circuit and ultimately, I would presume, reviewed by this court, will answer your question, Justice.
Counselor, I want to take you to your displacement argument, which clearly was at the heart of this decision, this court's decision in the American Electric Power case. I will say, however, we made that decision when EPA promulgated a number of rules that in fact very clearly impact virtually every aspect of greenhouse gases. But since that time, all of those rules have been challenged. And we have been told by the village that next month in the DC Circuit, they're going to have argument for 2 days on every one of those rules. And I take it as quite possible that the DC Circuit will in fact invalidate those rules. Why isn't your action your defense just premature right now? How can we decide any displacement until we wait to see what happens in the DC Circuit?
Well, going back to Justice Ginsburg's opinion, which was for unanimous court, this court's decision, she said in that decision that it wasn't the existence or the absence of regulations by the EPA that affected the displacement. It was the passage of the Clean Air Act itself, by which Congress entrusted the EPA with the authority to regulate and promulgate those particular standards. So it's not the question of whether these regulations are thrown out. It's not the question of whether they're affirmed. It's the actual Clean Air Act itself.
Well, let's talk about the Clean Air Act, because also since the time of our ruling in AEP, the House of Representatives has passed a series of laws that would either defer or invalidate those rules. I do not believe the Senate has acted on that. Why don't we wait for Congress to decide what they're going to do with those proposals? Why isn't it premature for that reason?
I think that we have to deal with the law as it currently exists, Your Honor. The court can, of course, in its own judgment, decide how quickly it rules in this matter. But I think the matter is ripe and before the court at this situation. And I don't think it would be appropriate for me to suggest that the court defer at this point to the speculation that the Congress may or may not pass a law. As we know, they're having difficulty getting things through on a regular basis right now anyway.
That appears to be true, Counselor. Our AEP decision was based, of course, on the petitioners, in that case, requesting that this court decide caps on CO2, but the village is asking something different. They're asking damages. Do you see that as a significant distinction between what we did in AEP and what you're arguing now?
I do not, and I agree with what Justice Starr said during my colleague's argument a while ago, and that is damages themselves are an effective way of achieving regulation. This court in the Cipollone decision versus Liggett Corp., which dealt with cigarette issues, held specifically that damages awards are regulatory in nature because they are coercive of conduct. To avoid getting hit with damages, you're going to change your conduct. So that whether you get hit with an injunction that says stop, or whether you get a $100 million award that says pay, it's still deeply influential and regulatory in nature as to how you're going to deal with the issues. In closing, I just want to bring home the point that with respect to this case, we're casting a jury out on what Justice Scalia called is a sea of imponderables. They will have to deal with and decide what is reasonable as a matter of policy. Do we have more electric cars here? Why isn't the automobile industry responsible for these situations? Why isn't the electric power industry? How do we decide what the level of reasonable emissions will be with respect to this limited group of people when we don't have the entire universe of emitters before us? And I think that is an imponderable situation. It's a situation that is unfairly entrusting and burdening a jury without resources, limited by the record of private parties, with a task that's almost impossible to accomplish. So I would respectfully request that the decision of the Ninth Circuit be affirmed.
Thank you, Your Honor. Just a few brief points. First of all, as to the causation theory underlying our claims and as to which we assert our standing argument, the allegations of the plaintiff's complaint seek to apply a well-established theory in the law, whereby, although the actions of a single defendant may by themselves not be significant, when those actions are shown to have substantially contributed to an indivisible injurious phenomenon, those actions then become legally significant because they demonstrate a substantial likelihood that the defendant's actions were a cause of the harm. This is a well-established common law theory. We seek only to apply it here. Similarly, as to the availability...
Do you allege that the defendants you have affected service on to date and that you brought in this lawsuit reach that threshold? Or do you just say they, together with some other people who could or might be found, would get, that you'll be able to prove that they reach the threshold?
No, we allege that these defendants have substantially contributed to the phenomenon of global warming. Our claims are not dependent upon the intervening actions of other parties not before the court or not within the control of the defendants. We seek to impose liability directly on these named defendants. And as to the availability of standards necessary to guide the courts have been guided well by the standards of the common law available in, for example, the restatement to guide the courts with respect to the litigation of public nuisance claims. If the courts have been able, as they have been in the past, to address the widespread effects of acid rain, the effects of dumping waste into our waterways, the effects of the widespread effects of bacterial infection that is dispersed into the environment, surely the courts are capable of adjudicating the causal relationship between the contributions of the defendants in this case and the injuries suffered by
Counselor, you've been relying on federal law and federal common law. Can this court delve into state law and see whether or not we can get any help there?
I certainly believe that the courts in the application of federal common law should look to the states for whatever guidance may be available in those precedents, but I think there is a well-established body of federal common law that can be applied here. And if I may, let me just comment very briefly on the claim that the allegations in our complaint will involve the courts in the kind of balancing that would require the courts to set policy, that juries will have to balance the utility of the conduct against the gravity of the harm. And that is simply not the case, because as I think the Chief Justice pointed out, where the harm is as severe as that alleged here, as severe and distinct from the harm suffered generally by the population, the question is not the utility of the conduct versus the gravity of the harm. The question is simply whether a plaintiff that has suffered such severe injury should be required to do so without compensation. Perhaps there is an element of balancing in that inquiry, but it is the kind of case-specific, fact-specific balancing that the courts undertake on a daily basis and that does not involve the courts in setting national policy, that does not encroach upon the legislative or executive branches of the government.
So this is the only such suit that you'll ever be a part of?
Well, that remains to be seen. And finally, the fact that we are seeking damages as opposed to injunctive relief is, I believe, a major distinction. We are not seeking prospective relief. We are not seeking an injunction. We are not seeking to set emission limits for the United States. We are not seeking to impose a parallel regulatory regime or to regulate the internal operations of the defendants. We are seeking only to apply the common law to the specific facts of this specific case for purposes of proving a claim for damages. That informs the political question analysis and dictates that under the prudential factors in Baker versus Carr, as well as the traditional textual test for political question, that there is no political question presented here. The courts are, by our allegations, simply being asked to do what the courts do all the time in adjudicating the tort claims that are assigned to them by Congress under their jurisdiction under Article 3. If there are no further questions, thank you very much, Your Honor.
Thank you, counsel. This cause is submitted on briefs and oral argument. The marshal will adjourn the court.
It's adjourned.
Should we get them to join us?
Let me thank everybody for a fantastic oral argument presentation. We are now going to have a bit of discussion about the oral argument you've just heard. Before we begin, I wanted to correct an omission on my part, which is I was so focused on introducing our panel, I failed to introduce our illustrious oral advocates as well.
Oh, they didn't have to.
Rick Faulk is currently the head of Gardere's litigation section, as well as its environmental group, as well as its climate change group. So he certainly brings a wealth of experience and a triple hitting threat to this argument. He also probably writes more than a lot of law professors I know and publishes in law reviews, so at some point we're going to steal him away to academia, I'm sure. David Axelrad is with Horvitz Levy in the Los Angeles area, who's been a partner since 1986 and has argued hundreds of appellate arguments, so this is all second nature for him as well. He's also published extensively and previously had worked at the Federal Trade Commission, so he has a bit of an agency perspective as well. So with that, I'd like to turn a little bit back to our bench as well as to our advocates. In particular, I was hoping that each of you could take a few minutes and just give your impressions of the arguments that were presented. I wouldn't ask you to forecast what your opinion would be, but what issues you thought were perhaps the most germane and which are issues you thought were the most interesting?
I mean, first of all, I want to congratulate both David and Rick. Those were outstanding arguments, you know. Those were just wonderful, and you're seeing, you know, two extraordinarily accomplished advocates in a courtroom, and you could watch all of us bombarding questions and trying to deal with various positions that we on the bench were taking, and I thought you were masterful in how you do that, and I congratulate both of you. For those of you in the audience, think about yourself in their position for a second. Here is an extraordinarily difficult case that was launched before the Supreme Court ruled in AEP. So if you look at your factual setting, you know, they filed the case, and then sort of midway through the case, the Supreme Court makes a decision. So first of all, you have to bring that to our attention. But second, now you have to deal with what the court said and what it didn't say. There were lots of things that were not said there. And I thought both of you did a fantastic job trying to use that decision in your best interest. And of course, we are dealing with fairly archaic subjects. Political question doctrine and Baker versus Carr and its 6 different parts and standing, what does all of that mean? And we of course then assume the facts. We assume that the village was hurt exactly the way that they were hurt in that case, and it's in the causal aspects of greenhouse gas which are enormously difficult in this context and raise not only domestic issues but raise international issues as well. I don't think you can pick up a newspaper in the country today that there won't be something on greenhouse gas or its effects. And that complicates what the advocates are arguing in this court. But I actually compliment both of you. I thought both of you did a good job of trying to present that, and if we were all deciding it, it would be difficult for us.
There was a great judge, federal appellate judge in the 20th century who served with great distinction, indeed brilliance, on the Second Circuit Court of Appeals in Foley Square in New York. His name was Henry Friendly. Experienced lawyers will know Judge Friendly's work, including his extrajudicial writings. Law students should not overlook that giant of the 20th century, but he was also a brilliant advocate during his years at the bar. And it was said at his memorial service in Foley Square that and this was said by the Chief Justice of the United States, that as an advocate, Henry Friendly evinced an attitude of respectful equality. That he was respectful, but he was having a conversation with the justices or the judges. So I associate myself with the comment made. I thought that the argument was just elegant on both David's side and Rick's. A couple of tips to the law students. Notice the responsiveness, very responsive. So there's no frustration on our part, whether you agreed or disagreed with the answer, that the question was being addressed and was respectfully addressed. And something that seems to be lost in the profession, or at least eroded, and that is these very brilliant advocates waited until in my case, long-winded judges or justices were through with their prolex compound question. That is very frustrating as an advocate, because you see your time marching on, you know you'll probably be held to the time, and you just sort of, come on, Ken, get to your point, ask your question, and shut up. But at least I didn't even see any body language to that effect, arched eyebrows, rolling eyes, and so forth. A tip on rebuttal, I thought David handled it brilliantly. He said rightly at the outset a few brief points, but of course he wasn't, right? He went on and argued, but it's soothingly reassuring to hear. It's gonna be, and so I thought that was very skillfully done. It was a very fine argument, but it is exactly right. And I thought he used the limited time very effectively, so it is good for you to say, I have a few points, or I would say even be more concrete, because it may help forestall that, which is the bane of the advocate's existence on rebuttal, which is you're asked a question. And you heard that. Two very brilliant judges ask questions on rebuttal as counsel trying to make your brief points, because these are the ones that you say, I'm going for the jugular, I'm going for the win, and suddenly you're off track. So that is an extraordinary skill that you just practice. What happens when I'm on point 2, but I need to get to point 3, and I just got a question from the judge? With respect to the substance, you've been kind enough not to ask us to decide it. I would just say, especially for the law students, think of this as a case involving judicial power. That's really what standing and the political question doctrines are really all about. And through what lens will the judge or justices be examining the case? And essentially, the world breaks into two types of judges. Those who love judicial power, and then those who are sort of skeptical and even, I don't think so. So, are you going to win on standing and political question in the Supreme Court? Well, we have an insight. It was 4-4. There are friends of judicial power on the Supreme Court, and then there's skeptics about judicial power. Call it conservative, call it liberal. I don't. I call it, do you love judicial power and to see a very robust judiciary out doing its work? Or are you saying, this is an unelected judiciary and they've got to be very careful and circumspect lest they intrude into the orderly work of the political branches, assuming, arguendo, that the political branches engage in orderly work. A brilliant argument.
I don't have to be as effusive as my colleagues because they've already said it, and if I tried to do more, I would fall flat. But I want to do no less and say that you all both did an excellent job and would set a high standard for anybody in the audience to try to come close to if they had to argue a case of this difficulty or complexity. On the merits, as it comes down to us, it does seem like standing and political question kept bleeding into each other. And I don't know that a court would decide this in neat little boxes either. They would just try to say, okay, you know, is this a one-off event? And I couldn't get David to admit that he might, if he won here, he might not try to pick up another $400 million down the road with the village that was only going to be 3/4 inundated. So, but I think that would make a lot of difference to the court. Could they see that this really was a unique situation such that it could go to trial, and you would trust a jury to say yes or no, there was causation here after they heard about 3 months of experts, and you admonished them not to listen to Rush Limbaugh on the radio coming to or from the daily court, or do you think this really would be juries setting the conduct of a vital set of national industries on a one-by-one basis, and that everybody would bring a claim and everybody would get past summary judgment or motion to dismiss and you know, try to get their $400 million as well. So this was a tough case from the first. for the plaintiffs, and it remains a tough case, and it didn't get any easier after AEP, where the Second Circuit opinion is cited on about every third page of their brief to the Ninth Circuit, and now they've just got to say, you know, forget about those citations. Those were on other points, and it's a distinguishable case. So it's a tough case for Kivalina, but you've certainly heard it presented brilliantly here, and I was tempted throughout to say, well, you know, the people are probably underemployed up there in that district of Alaska anyway. Let's see what a jury thinks about this. These are interesting questions to all of us. So we'll know, I guess, before too long what the Ninth Circuit does, and then this probably will come back with AEP to the Supreme Court again, and I predict we'll spawn more questions somewhere else, but if it doesn't, then we were lucky to be here at this day and place when these interesting issues could be discussed in an open fashion.
All right, and not to spring a small surprise on our advocates, but since our judges have spoken, I would be curious as to your perspective as to the issues that pose the most challenges for you during the oral argument, and any other perspective I want to offer to folks in the audience today.
Since I'm closest to him, I'll talk first, since you talk first all the time. One of the things that happens in these oral arguments is that you walk in and you think, I'm prepared and I'm going to give this argument. One of the things you find out when these gentlemen are up there is it's not your argument, it's theirs. And no matter how well you think you're prepared, no matter what you think you're going to say, sometimes you just don't get it out. It doesn't come out the way you want to because they throw the proverbial monkey wrench into the arguments, and you have to adjust. And you can't say everything that you want to say. You can't say everything the way you want to say it. And it becomes really sometimes very awkward, as just Starr mentioned, when the court just carries on and your time is clicking. And you're thinking, gosh, I've got this wonderful finale. Am I going to get to do this? And I think that was really that's a huge teaching point, because when you walk into the Supreme Court of the United States and you stand up, you can't have a prepared speech. It doesn't work that way. You're engaged in a conversation with people who are incredibly well prepared, who have read everything, who have had people help them read everything. And they are, if anything, more prepared than you are, because it's their court and they're going to make the decision. And I think that's one of the things you have to be prepared to deal with, is that you have to have a dialogue. You can't be impatient. You can't be inflexible. You have to, in a real sense, if you're doing it right, it's more formal, but you're sitting across the coffee table in a respectful way, talking to people about things that matter. And the worst part about it is that you can't pass them a bottle of wine or or a glass of wine, maybe a bottle would be better, to kind of mellow things over. It can sometimes be very intense. One of the things you may have noticed is that there were at times kind of arguing between themselves through us, and you're kind of in the middle with the vice being pressed, and it's a very vulnerable situation, and the only way to deal with it is just to be absolutely, absolutely, absolutely prepared. So, David, you want to comment?
I just wanted to comment very briefly on the merits and the dynamics of the argument, and what from my perspective, was the most difficult part of the argument, and the part of the argument where Rick gave me the most trouble. And I think that has to do with the sort of standardless inquiry aspect of the whole issue. My job was to paint this as a conventional common law tort claim that's not unlike any other common law tort claim that the courts routinely will entertain. And that the fact that it's has a larger scope to it is simply a difference of degree and not a difference in kind. But when you get to something like global warming, the concern is, I think that, and that where my weak point was, is that it becomes so large, so complex, involves so many public policy, foreign policy, political overtones to it, that it really becomes the kind of thing that even if the courts could become involved technically, they shouldn't become involved with. And that's where I think Justice Cruden was heading with his question about prudential standing, that this is just something that really should be left to the legislative and political branches because of its size and complexity. That's really a difference, becomes a difference in kind, not just a difference in degree, that should lead the courts to decline to exercise jurisdiction. That, I think, was the hardest thing for me to be fighting against.
So you haven't spent your money yet, in other words.
Not quite yet.
And I can't resist noting in passing that Justice Cruden was involved in drafting the prudential standing arguments in the Connecticut versus AP briefing to the Supreme Court.
True.
Now, one other quick question I wanted to perhaps throw this as a privilege of the moderator here for today. I'll throw out the first question, but I'd like for everyone in the audience to think about questions you would like to ask next as well. I was very intrigued by the Honorable Justice Cruden's question about the role of state law. And in particular, if the battles over justiciability, political question, and standing are really deeply rooted in the ability of the federal courts to hear these claims, assuming that that review is constrained at some point by a decision, what role will the state courts then have in perhaps picking up these suits in the future? And perhaps this entire battle over federal jurisdiction is really a prelude to other levels of litigation. And I throw that open to all of you if you care to make a comment on it.
Well, state courts are active right now in the public nuisance question. That tort has been around for a few hundred years, but it's been quiet until recently. And I think starting in the tobacco cases, it was discovered that if your case has really insurmountable problems on limitation and causation, if you can just somehow trick the state into taking the case as a plaintiff, the rules are more rigged in their favor, and they might get a good result. But in this kind of case, I think it would be very doubtful that the federal system would allow the state to exercise its range, because there's really nothing the defendants could do to protect themselves. I mean, it's a problem even with a national case. You can't build a wall that keeps the carbon just within the territory of the state of Missouri, for instance. It's going to go everywhere, nor can you keep the Chinese from doing whatever they're doing, and that's going to make your own exposure or your own damages go up, even if you decide to go out of business in order to, or you do decide to shut down the entire electric industry or something in Missouri in order to protect yourself. So that the tort law, which does have, as Justice Starr pointed out, the effect, it's supposed to have the effect of changing behavior. But it couldn't really operate under this particular claim, I don't think. And I don't believe any state court would even try to take a case like this one. And if they did, I think it would somehow get to the U.S. Supreme Court pretty quick and be stopped. Just a guess.
I think it's a very good point. I mean, I asked the question for two reasons. One of them is just totally mundane. Right about the rebuttal time, most judges are thinking about the opinion that they're going to be rendering. And so now, do I have to look up state law or not? Is that relevant to that decision? Because we're talking about the common law issue. So that was just a mundane question. But there was another, a more practical. In the AEP case, so this is the case the Supreme Court just decided. It was not actually a clear victory, and they remanded to the Second Circuit because the state law claims were not considered. And so it was remanded back. Ultimately probably to the district court, so they can consider the state law claims. because the AEP decision was exclusively federal. So that was the other reason why I asked that question.
But was that for state regulation?
State regulations, right? Well,
Which
it's
is
a
again
state common law. It's a state common law as well. But I still thought David's answer was actually quite good, because when you're, what is the federal common law? Is state law not applicable in some way to the federal common law? And I think you can make an argument that it is. But in this case as well, in the Ninth Circuit case, they actually preserved their state law claims. Those were preserved.
And notice in their brief, though, they undercut I thought, the validity of those state law claims by pointing out how universal this was, and the federal court should take it. And then there's a footnote, but if we lose on that, we reserve our rights.
Right.
There does seem something inherently, shall I say, interstate, in fact, international and global, that suggests, at least intuitively, that while the question hasn't been authoritatively resolved, there's a lack of fit between state law and global warming. Now, you can respond by saying, wait, state tort law is really the same virtually from state to state, with perhaps the exception being Louisiana, and even there may not be material differences, thanks to the restatement, on which all parties will rely. But it would seem odd for a plaintiff to say, I am invoking my state's law to sue these corporations and entities for damage done around the globe, but I've been especially affected right here in Connecticut. So I would just echo, especially what our chief said. It's very different, though, if the state as sovereign comes in and says, we're invoking state law to protect our citizens, as opposed to, with all due respect, a private entity saying, please send us money here in Alaska.
Thank you. I'll open the floor to questions. Would anyone like to ask a question either to our illustrious bench or to our advocates?
I think I've got a pretty loud voice.
Well, and I'll probably repeat your question anyway, just because for folks on the internet, they may not be able to hear you.
Right. I guess this is a general question to everyone, because I thought there was one line of questioning, though, that's interesting, because there's all these complex issues of standing and political question, but it still comes down to a certain level of you're assuming the facts as pled are correct. So you're saying there is some level of causation, there is some level of injury, and at what point do you just say, even with all this self-evident injury, tough luck, take your chances on Capitol Hill? And I'm just sort of curious, outside the formalities of oral argument, either with our esteemed judicial panel or our advocates, how do you sort of address almost the front page of the newspaper element? Sort of the tough luck response.
I wouldn't say tough luck, but I would say, if you look at the AEP decision, despite the fact, and I was at Department of Justice at the time we were doing that, but we could fill this table full of pleadings talking about standing and prudential standing and all the various factors of Baker versus Carr, and the Supreme Court and AEP did that in a paragraph, one paragraph, and went right through it like a truck going down the interstate, and they got right to displacement. And the court said, Congress has spoken. Congress has spoken. They gave authority to EPA, and essentially, if people want to change that, then go back to Congress. It's displaced. It's displaced by what Congress has done in that regard. You saw in my questions, I was trying, but actually I think you did it, Rick. You were right. I believe you're right. I tried to use the fact that Congress is reconsidering some of those issues. There's, countless numbers of those. Rick said, good thought, Justice, but why don't we wait, until that's decided, then the law is what the law is today. And I think you were right in your response. But I tried to take you down that route of looking what was happening on the Hill today. But I think the AEP decision is somewhat clear in the sense that it is displaced, and it's not displaced by what EPA did. It's displaced simply because the laws exist and gave EPA the authority to regulate in this area.
What makes this case particularly tough to me, and I asked the question twice, and So I'm either obviously just off base or I'm so right there's no answer. But this is an area where there are winners and losers. And even in your own individual life, you may have the climate's been changing since the planet cooled. It continues to change. Man may or may not, and the jury may decide that may or may not really have speeded up that change or made it more pronounced due to the conduct of these defendants and others. But even if they do, it's not like you're an automobile accident, or it's not like somebody dumped 2 inches of coal soot on you and there's no good in it. I mean, this is something that's going to bring net good to some people, net bad to others, and people may disagree about whether, same thing may happen to 2 people, and one of them think, well, that's good, I hate the winter, and somebody else think it's bad. This little village of Kivalina, appears to have been rather uniquely hard hit, but who knows if some of those people have relatives or land up in the interior that's going to be vastly more valuable. I don't know. So to me, this tort is almost uniquely difficult because it's really only alleges the acceleration of the kind of phenomenon that happens anyway, and because different people are going to perceive its effects in such different ways. I was asking the attorneys facetiously, since I was the first one here, if you get hit, can you then bring a claim, some kind of quantum of merit or undeserved benefit against the person who all of a sudden has rich farmland instead of frozen tundra? Can the oil company mitigate its harm that way so that we have the courts, with lawyers taking a little just off the top, sort of making sure that everybody stays in the position they used to be in and they don't get some kind of windfall or terrible harm? And the answer, alas, was no. We probably cannot get a 1/3 contingency fee to help even the world back out to everybody's natural place. But I think this makes a tough case, and I think you could say no in this case, and even be very sympathetic to lawsuits and causes of action for injury and nuisance as a general rule.
Well, I would make, especially, I didn't know the law students had to go to class, but I would make a sort of didactic point, and I was just reminded by the question of what Professor Larry Tribe has said about constitutional law in general, and political question, doctrine, and standing in the heartland of constitutional law. They're just at the portal into which you then go. And that's the inevitability of judicial choice. You're going to make a choice as a judge. Which way are you going to go? Because the answer is not going to be discovered like the laws of mathematics. And both standing and political question doctrine are just rich with the opportunity for judicial choice. Am I going to allow this to go forward? There's not going to be a case right on point. But where the court, even though it was divided 4-4 on standing and political questions, so there you have it. Progressives versus however you want to characterize it. Again, I prefer not, I like to just think of it because I think the court tends to divide along the lines of judicial power friends or judicial power skeptics. But where the court came together, and I think this is instructive for all of us, not just the law students, is, aha, the EPA is at work, we're going to say that's it. And they did move the law in that respect, right? Because it wasn't that EPA had issued any regulations. The court was willing, as it were, to wash its hands of this and get rid of this very pesky and complex set of issues that we've been struggling with by saying the policy choice by Congress to ask the EPA to become involved is sufficient for us to say we are out of business. And that was 8-0. So that's very, I think, indicative of this court, whether they're friends of judicial power or skeptics of judicial power, will likely come together if they can find a way to say, there really are agencies out there, EPA, that is really more consistent with the political dynamics, the political process, which brings Scalia and Breyer together. Breyer active liberty. We want the people participating. We want the judges to interpret the Constitution in such a way that it encourages the great conversation and the political branches to do the thing. And then Scalia as the quintessential judicial skeptic saying judges shouldn't be running the world.
I just got to answer Chris's question in this way. Some of the judges up there know a judge who's passed away now by the name of Clarence Guittard, who was one of the first law clerks for the Supreme Court of Texas back in the old days. And he was on the Court of Appeals in Dallas when I worked there. And it came up, this question of tough luck, of what happens when we say no, or what happens when we find a bad law and we're going to decide whether we're going to enforce it or not because the consequences are going to be terrible if we do this. And one of the wisest things that he ever told me, and I don't know that he always lived by this, but he said, when you have a bad law, the best way to change it is to enforce it, because then the people will do something about it. The political system will do something about it. And I kind of think the same thing has to be true a little bit with tough cases, where sometimes the law says you have to say no. And if that's a problem, the people will change it. The political system will deal with it. The Congress or the EPA or somebody will do something about it. It's when we start vacillating and we start saying, well, you know, Congress hasn't acted on this, and so we got to do something. We need to stretch this a little bit. And I'm not sure that's exactly the judicial mindset. Never sat up there. But it's when we start stretching the law, when we start reaching, when we start saying the silence of Congress on this, we can't have this injustice result, so we're going to change the law. I don't know, but I think that's when problems start. That's when trouble begins. There may be circumstances for it, but I think saying no is sometimes a good thing.
I just wanted to comment on the overall appellate posture of this case and how it relates to the question that you're asking. It's often most difficult to defend on appeal cases that have been dismissed at the pleading stage, because you have to treat all the facts alleged in the complaint as true. So that makes it very, very difficult to make your arguments, because all of these allegations have to be accepted. So that's what makes it difficult for Rick, and that's one of my principal advantages on appeal. And I think you could see that from Justice Starr's questions. You know, well, if all of these allegations are true, why don't we just let them go forward and see what happens at trial?
And offer just two quick grace notes. I just would like to point out to folks that Justice Phillips' questions about climate winners as well as losers is actually becoming a fairly active area of environmental legal scholarship. And if those of you who are interested in how that will affect claims, there are some professors who are actually looking into that very closely. So it's a live issue now. Particularly would recommend you take a look at future publications by Professor J.B. Rule at Vanderbilt University. With that, I know that's been a bit of an extended lunch hour. We have time for probably one more question, if anyone would like to. Here we go.
I was curious how strongly you feel when you argue that only states would have the quasi-sovereign interest or parents' patriarch standing, as in Massachusetts, the EPA. I think you mentioned there were no Supreme Court cases other than involving states. Would you take it through the next step and say that you wouldn't think that a municipality, a county, or a tribal nation would not have parents' patriarch or quasi-sovereign interest?
Yeah, I think I would take that point until the Supreme Court told me otherwise. Of course, they changed their mind, but the states are a pretty unique situation because they have plenary political authority. They don't have kind of the narrow interests that a city or an Indian tribe or some other sort of political division has. And in fact, they are really the only entity, I think, that has the authority to enter into a dispute with another state, for example, which is, let's say there's cross-border pollution. I think that the state is the representative of the city, the political subdivision, and otherwise in pursuing that relief. So I really think that states really should be, as far as federal common law actions are concerned, not citizen suits and things like that, but as far as lawsuits like this are concerned, I think they should only be pursued by states. John, you may have some comments.
Yeah, I think this is a difficult issue. You could see what I tried to do early on with David, essentially saying, shows over, you know, the Supreme Court said it in AEP, special solicitude for states. Tribes are the functional equivalent of states. They're sovereign, and therefore it's over. I don't actually think, notwithstanding my question, it's quite that easy. That was a very controversial part of the AEP decision. There's obviously 4 votes against that position. That line in the Supreme Court decision of special solicitude has been analyzed in numerous law review articles right now. I would say probably the consensus is that's about as far as the Supreme Court is willing to go right now, is states there. But your question is, so what would distinguish a state sovereign capacity from a tribe or from a local government? I think Rick's right. That's open area for argument right now. But it is, in fact, you know, a key part. But that's what I tried to do with you, David, because I was saying, well, it's straightforward. It's straightforward. Tribe gets the same status as the state, and therefore you get the protection of the AEP decision.
And I'll just note in passing, for those of you who want to study potential future directions on this, the 4-4 split in the Supreme Court resulted because one justice recused herself, Justice Sotomayor, because she was involved in the Second Circuit's evaluation of the case. I would suggest that a lot of folks will be looking at her prior decisions very closely because she'll likely be the thumb on the scale for the future decision in this area. With that, I'd like to thank our panel and our advocates for an excellent presentation today. And a final reminder for those of you who need CLE, be sure to do your forms. And a last announcement, if this has gotten you in an environmental mood, we're actually going to be having a tree planting event at the University of Houston Law School to replace trees that were killed by the drought. So if you'd like to come out on a Saturday morning and help plant trees and have a family event afterwards, please join us. We have flyers for it in the back of the room as well. Thank you again.